Welcome, everybody. My name is Paula Price, and I'm with the People's Law School. And today we are presenting Buying a Used Car in British Columbia. And we've got two amazing speakers. We have Ian Crispin from the Vehicle Sales Authority of BC and Mario Garcia, a lawyer with Ratcliffe and Company, LLP. And welcome, both of you. We are so excited. I'll be doing the formal introductions in a minute. For now, I wanted to introduce the topic. The used car pages on our website are some of the most popular pages, tens of thousands of visits every year. And the majority of those visits are for individuals who are looking for information about problems that they have with their used cars. So in this webinar, we are going to talk about ways that you can solve those problems when they arise, and hopefully also share information with you that will prevent you from getting into those problems in the first place. We're getting very close to introducing our speakers. I know you're all very excited to meet them. Before we do that, I would just like to acknowledge that the land on which the people gathered is the unceded territory of the Coast Salish peoples, made up of the Musqueam, Squamish, and Tsleil-Waututh First Nations. And as we make our land acknowledgements, I would encourage you to reflect on the land that you're joining us from today. And we are posting in the chat a link to an interactive map to help you check out which First Nation territory you're located on today. We would also like to acknowledge the funders who make today's webinar possible. And those are the Department of Justice Canada and the Law Foundation of British Columbia. And finally, I am so delighted to extend our thank yous, our gratitude to our speakers today. I'll introduce them in sequence. We have Ian Crispin. He is the Chief Legal Officer and Registrar of the Vehicle Sales Authority of British Columbia. And Ian has been a contributor to a number of resources that we have on the Dial a Law web page. And he has done reviewed materials on car leasing, buying a used car, and dealing with mechanics and repairs. Really full information. We'll again be linking to those resources. He is a wealth of information, particularly when it comes to cars that you buy through dealerships. And we are so excited to have him here today. So welcome, Ian. Thank you so much for joining us today.
Thank you, Paul. Thank you for having me. It's a pleasure to be here.
Thank you so much. We also have Mario Garcia, and Mario is a lawyer with the law firm Ratcliffe and Company in North Vancouver. Mario also has been a major contributor to the web pages on the People's Law School website about buying a used car. And one of those pages includes one of our most frequently visited pages about what happens when you buy a used car and it has problems. And that's a question that we'll be dealing with in a few minutes in the body of our Q&A section. And so just wanted to say a big welcome to you, Mario. Thank you so much for joining us here today. It's so great to have you here.
Thanks, Paula, and it's a pleasure to join you in the end today.
Thank you so much. Okay, so we're going to dive into our questions. The first question that we have is for Ian, and I'll read it out. I saw a car that I like at a dealership. My neighbor has the same car and she offered to sell it to me for half of what the dealer is asking. Is there any downside in going with a private sale?
It really is a personal choice of what you're comfortable with. There are some positive pros, certainly, to going to a dealer. First of all, there's various laws that require dealers to make disclosures about the vehicle they're selling you, the used vehicle. For instance, they have to research and determine whether there's been any prior accident history of the vehicle, and if there's damage over 2,000, they have to disclose that to the buyer. If it's been an emergency vehicle or if it's been imported from another province for the purpose of resale. They also have to ensure that the vehicle they're selling you meets the safety requirements of the Motor Vehicle Act, and before they sell it to you. Another benefit is that there are provisions in the Business Practices and Consumer Protection Act that protect consumers about some of the things that a dealer can or cannot say or do in relation to marketing that vehicle or trying to get you to buy it, and some other disclosures they have to make to it. The other thing to note is if something goes wrong with that purchase, it's a business, they're identifiable, and there's a body, ourselves, the Vehicle Sales Authority, that you come to with a complaint if you need to file a complaint. As well as there is a motor dealer customer compensation fund. We have an insurance fund up to $20,000 per claim. So if there's something that goes wrong, it's within the bounds of that claim, and the law that allows claims, you can have access to that if something should go wrong with the purchase. So that's a possibility. If you have a vehicle that you want to trade in, instead of reselling your vehicle privately, you can bring it to the dealer and use it as a trade-in. There's actually a tax advantage to doing that. A trade-in value of a vehicle gets applied to the purchase price of the car you want to buy to deduct that value before taxes. So if you're buying a $30,000 car and you have a $10,000 car that you want to trade in, that means you're paying $20,000 in tax for taxes on $20,000 only. So there's a benefit, because that $10,000 actually reduces the price of the car by quick math, $11,200. Some of the benefits to doing privately is sometimes you can make a better deal in terms of price. Sometimes, if you know who the person you're buying from, such as your relative, you might have some more assurances about the history of the vehicle. And generally, when you buy it privately, there's no GST. The BC government just collects the PST at the time of you registering the vehicle. So there are quite a lot of advantages, and we always say you need to feel comfortable with the choice you're making and know the buyer that you're buying from, especially when it's private.
Fabulous. Thank you, Ian. So just to recap, I mean, it sounds like at a dealership, there are a lot of rules and regulations that the dealer needs to comply with. So you talked about disclosure. For example, if there's been an accident over, I think it's 2000, if you have used that car for a rental car, for example, that there are safety requirements that they are required. It sounds like they're required to actually test the car to make sure that the car does meet a certain standard of safety. And
Yep.
And as you mentioned, which I think is very interesting, this idea that there's a complaint process, and I think we'll touch on this in a later slide. There's a complaint process, there's a compensation fund available, and this tax trade-off, which sounds like it could be very advantageous, are all reasons in favor of going with a dealer. But there are also reasons why you may want to go with a private seller, but you would not necessarily have those same protections that are built into the system.
That is correct, Paula.
Fabulous. Yes. Fabulous. Thank you very much, Ian. Mario, the next question is for you. I'll read it out. I bought a car from a private seller who said the car was fully serviced. I had problems right away, and my mechanic says the car is unsafe to drive. Now what?
So thanks, Paula. So one of the first things to do in this kind of circumstances is, to the greatest extent possible, try to reduce using the car after it has been deemed that it's not fully working. And we'll get to why you need to do that in a little bit. So generally speaking, when you're buying a car through a private seller, you are entering into a contract to buy that car. So the general contract law of contracts applies. And what this means is that in exchange for the car, you are paying money. You're creating something that the law recognizes as you have a right over. In this particular circumstance, where there was a statement and it says it was fully serviced, we are in the context of misrepresentation. And misrepresentation occurs when three things happen at the same time. One is that the person making the statement made a statement that was not true, or was made in a way that it was misleading. Two, the person making that statement should have known that the statement was false. So there was very clearly the person had previously encountered considerable issues with the car and was selling it for that issue, because of that issue, and to you as a buyer. And then because you relied on that, so the third element would be you relied on that statement, it was fully serviced, so then you went ahead and purchased a car. it kind of sounds a little bit too straightforward, and unfortunately it's not as that's the case. So the reason is because we usually fall in a situation of one person is saying one thing and the other person is saying another thing. Now, you as a party who is the party suffering the wrongdoing, you need to go out there and actually prove that the misrepresentation happened. And this entails providing evidence on the circumstances of the sale. So was it something that it was said? That can be pretty hard to prove. But if it's something that was in writing, that's a little bit easier. And did you keep records, and how well those records were kept, and whether you can track the advertisement that said it was fully serviced or not. So one of the big themes around this talk is how you can take steps to prevent or kind of safeguard your rights when you're buying the car. And one of those things is making sure that when you're purchasing the car, make copies or take screenshots of the ad that you're trying to buy, or take screenshots of the text messages that you're exchanging with the buyer. So that's one of the tricky things. One is you have the burden of proof, and two, once you finally say, well, I have enough evidence here to prove my case, then you have to think about what is the remedy that you're trying to access. If you bought from someone who is reasonable and they acknowledge their wrongdoing, you can get as much as a remedy as essentially the agreement is canceled, you get your money back, they take the car back. This can be a little bit more complicated because the other person might simply say, I don't want to do that. So depending on how strong your claim is and how clearly wrong they acted, you might be able to get them to pay for the repairs that the car needs, or just to a certain level, depending on how much the car was worth, how much you invested in it, and how much you actually want to pursue this in a way that actually looks at your rights. You can access dispute resolution mechanisms like the civil resolution tribunal to actually get the money back for your car. So it depends a lot on, once you have the evidence to back up your claim, whether you can move forward and engage with it. So it's unfortunately, the remedy is it depends a lot in the circumstances, and sometimes it might be as easy as sending a letter and seeing how well they respond, to sometimes if you really feel that you need to resolve this through a court system, then you can engage that process, but always noting that process tends to be expensive, and that's why you want to avoid those issues and ask the right questions before you purchase a car.
100%. And I love how you've really focused on what you can do after the fact, or things that you should be keeping track of as you go through the process. So making sure you're building up all the proof, as you called it, the text messages, the advertisements, the representations that were made. You mentioned at the beginning, Mario, not to use the car, and I may have missed the connection there. So if you discover that there's an issue with it, and to not use it, and why is that?
And so again, when we're coming back to the idea that you're trying to prove that that car was sold to you in a faulty way, you don't want to give the ability to the other party to say, no, the reason it's not working is because the way you have either treated it wrongly or you're overusing it at this point. So to the extent that you're able to say, look, it broke down within 2 days and I haven't touched it since, that's going to give you a stronger case than to say, look, it broke down in 2 days, but I still drove it around everywhere because I really needed to do it. I mean, in certain circumstances, a party might not be able to stop using the car, but it is more advantageous in that particular context to really pause and maybe stop using the car if you want to keep your rights, quote unquote, intact, right? So, yeah.
Fabulous. Thank you. Thank you so much, Mario. That's really helpful. Our next question is for you, Ian, and I'll read this one out. I bought a used car from a dealership a couple of months ago. It's already needed multiple repairs. Can I get the dealer to pay for them?
That's a good question, Paul, and it actually kind of dovetails on what Mario was just speaking about. It all depends on the situation and the facts. There's no automatic right to do that in the law. So it really depends on what the parties have said during the negotiations. Sometimes a dealer will provide a 6-month powertrain warranty with all their purchases. In which case, yes, you could probably go back and get the dealer to pay for it if it's a powertrain issue. Um, Otherwise, if it's a used vehicle, there's generally what's known as an implied warranty that is durable at the time of being purchased. And what that means is dependent on the type of car bought, how old it is, how much mileage it has been, what's use has been put to Mario's point, how you've used it. And the courts sort of assess those things and say, the car was a 2-year-old car, only had 20,000 kilometers, and broke down 3 days later. That's probably something where the court's going to say, yes, you probably should be reimbursed for the repairs. There's another case that Maria and I both know about where a car was purchased. It was 7 years old, 160 or 80,000 kilometers, and it broke down within 530 days. Its engine failed. And the court found that the failure was due to normal wear and tear of the engine. The dealer did not represent the car as being like a great car or anything. They just said it's a used car, it is what it is. And the court says it was reasonably durable at the time of purchase, and the dealer was not responsible. So it really depends on the situation. So it's important when you're buying a used car, especially from a dealer, to ask things such as warranties. Get it in writing if their dealer is going to warrant and what they're going to warrant. If the dealer says it's a great commuter car, then that will expand how long that car should be durable afterwards. But generally, there's no automatic right simply because you bought a car from the dealer that they're responsible for the car for a certain period of time. It's very fact dependent. Also, dealers will most often offer to, when on a used car, sell a used car warranty program. So that's another thing for the consumers to think about. Sometimes when the dealer offers a warranty and the consumer declines, the court will take that into consideration, that the consumer is aware that there was no warranty by the dealer. So it's very fact dependent. Um, I would simply say, if you're concerned about a used car and how long it's going to go without needing repairs, that's something you should talk to the dealer about, maybe including into the purchase agreement as a condition of the purchase. The dealer will warrant the vehicle from repairs for however long that you can agree to.
Fabulous. And Ian, you on one of your pages that you reviewed for the Dialogue site, you'd mentioned that there were a number of recourses available when you buy a car through a dealership. Would you mind just kind of quickly mentioning what those are? So
Sure. You can file a complaint with ourselves, and we can look into it. I'll say that much of what we've talked about, Maura and I, is under the Sale of Goods Act, and we can't administer that. You have to go to the court for that. But we can look at whether the dealer's made a misrepresentation about the vehicle to you, and we can deal with that issue. And another issue is, of course, the courts process. And then the third one is something for a newer vehicle, including a used vehicle that's still under a manufacturer's warranty. There's a program called the Canadian Motor Vehicle Arbitration Plan, commonly referred to as CAMVAP. There are various manufacturers, not all, but various manufacturers who voluntarily subscribe to that program. So if you're having an issue with your vehicle, it can't seem to get it repaired, or seems to constantly be needing the same repair, you can apply to CAMVAP for an arbitrator to review your case, and they can make any types of award, such as requiring the manufacturer to pay for further repairs, or even in some extreme cases to buy back the vehicle. So that's an option that is also available, and that's the Canadian Motor Vehicle Arbitration Plan.
thank you so much, Ian. I think those are recourses people might not know about, and we'll be providing links to those along with the recording. It's very helpful. Thank you. So this next question is for you, Mario, which is, I bought a used car that drove down the first time I drove it. What can I do? And this is the one that I had mentioned had the most number of views, or one of, not the most, but one of the top viewed pages in the reference to a private seller. So we'd love to hear from you, Mario, in terms of what you can do in that situation.
Thanks. So as we discussed in the previous question, this essentially engages, it's a contract. And one of the things that perhaps the audience is starting to notice is that Ian and I are talking a lot about the contract, what is being negotiated between the parties. Again, unlike a contract where there's two business partners or two business parties dealing at arm's length or separate from each other, the law in this particular context steps in to say there are legal warranties that you cannot exclude just because you don't say them. So essentially, the law is implying that a car will last for a certain period of time that is reasonable in the circumstances. To do this, the law will look at the age of the car, how many kilometers it has, how much you paid for that car. And one important factor is whether the contract that was created between the two parties actually said, or expressly, so in writing, had said something about, no, I'm not providing you with this warranty. Essentially, like, you're taking this car as is, and you cannot expect it to work in any particular way. I think the easiest way to think about this, and I saw a question that was asking about the do's and don'ts about trying to buy a car. I don't think there's a particular checklist. I mean, unless you're a mechanic that you want to run over in terms of what rights you have and you don't have. The thing that you want to assess, and this takes us back a little bit to Ian's first couple of comments, was depends on what type of risk you're willing to take. So for example, if you're willing to pay $200 for a car that has 300,000 kilometers, it is very unlikely that the law is going to be sympathetic to a case where the car breaks down within a week. It's very unlikely. Now, you pay $30,000 for a used car that only has 20,000 kilometers and it breaks down, then to the extent that that legal warranty wasn't excluded in the contract, then you have a remedy. That again, and now stepping back to my previous point, is it's not as easy as just simply saying these three circumstances have happened. One, you have to prove that there were certain expectations that are not being met, and two, you have to determine how comfortable you are in proceeding in a legal case. So either you're just simply trying to get the money back from the seller, or you are actually going to pursue this action through adjudication system or through a court system. So depending on the value, again, if it's $5,000 or less, you can access the Civil Resolution Tribunal. But if the value is a little bit higher, then you have to start considering whether you go through the small claims court, or even presumably a very expensive court can actually require you to access a full court system, which would be very expensive in any event. So that's something to think about, that when you're thinking about how you can fix this problem. Usually the best thing to do is, once you have a particular case built, and by that I mean once you have assessed how much you paid, essentially assess the circumstances around what happened, is to engage the seller and try to be as reasonable as possible with them in saying, look, you offered this and I got this. I think I deserve something in return. You might want to say, take the car back. They might say no, and then you can negotiate what is it that you can actually get back. Maybe they can pay for some of the repairs. Maybe they can offer you some value over the car. But it's very depending on the circumstances. So I'll stop at that point. Yeah.
Yeah, and thank you for highlighting that, Mario. I think one of the points that you've made there, you've made many excellent points, but I think really focusing on, what are you going to do about it? And your first recourse is really to go back to the seller. And if that doesn't work, there are other options. The CRT you mentioned for claims up to, $5,000. Then there's the small claims court, which would be your next option. And, only really in exceptional circumstances would you be at the Supreme Court. And to really look at, what I'm gathering from that is to really look at the amount of money that is at stake relative to the money that you're going to spend on that process, or the time that you're going to spend on that process. So all these factors come into play in that respect. Ian, did you have anything that you wanted to add to this particular question?
Yeah, I'll look at it from the motor dealer aspect. If you've bought from a motor dealer and this happens, we can certainly look at it from a complaints point of view. We would look at the breakdown to see if it was something related to them, not meeting the requirements of the Motor Vehicle Act, in which case the dealer would be considered offside the legislation, and we can interject and see what we can do to resolve the issue. One thing I would say about motor dealers is that if you go back to the dealer and tell them, you've got this issue, they're usually willing to do something because it's a reputational thing for them. They want to keep their customers happy, and it's a business decision for them. We find that name brand dealers like your GMs and so forth, who have a manufacturer they have to be responsible for customers' satisfaction, generally are even more responsive that way. I'm not going to say that all of them are, but certainly most of them do so. And I think it's also important to remember for people here that, when you go to a GM dealer, that is owned by an individual business. It's not owned by GM Canada. Almost all franchise dealers are individually owned. The exception to that is Tesla, which is owned by the manufacturer. So these are individual businesses, usually sometimes are large dealer groups, but a lot of your one or two owners. And they're embedded in the community. So reputation is important to them. So going back and talking to the dealer, explaining your concerns, looking for that customer satisfaction aspect is a great starting point. If not, then again, you can come to the VSA and file a complaint. And again, there's that CAM app is available to you as well.
Super. Thank you so much, Ian. So our next question is for you, Ian. The dealer asked me to put down a deposit while I arrange my finances. Is that normal?
Paula, yes, this is actually a normal part of the business, especially as you get into more of the luxury brands of the vehicles. And I would say that what people may not understand is when you place a deposit down, what that does is it secures your performance of the contract. It's not a down payment on the vehicle itself. It's your commitment to completing the contract. And if for whatever reason you go to your finances and you don't like it, and you're going to walk away, the law in BC is that the dealer is allowed to keep that deposit, because it's not about the car, it's about you not performing the contract. And if you do complete the contract, though, the deposit has to be put down towards the down payment, of course. And if during this time the dealer decides to walk away from the deal, then the dealer has to return the deposit. So yes, it does happen, especially more in the luxury vehicles, and it's to secure your performance of the contract. It's not a down payment on the vehicle itself.
Super. Thank you very much, Ian. Ian, our next question is for you as well. I just bought a car at a dealership. I wanted time to think about it, but the salesperson told me the price was about to go up. A week later, I saw the same car listed at the same price. Can I get out of the deal?
Thanks, Paula. Based on the information, there's been a misrepresentation, and we can certainly look at that under the Business Practices and Consumer Protection Act. That legislation doesn't necessarily say there's an automatic right to cancel a deal. We have to look at all the facts to say how were you harmed in this, and what is the level of that harm. And if it's, for instance, you could have gotten the car for a few $1,000s less, maybe that is what the consumer's remedy is. So there's various Court of Appeal decisions that have said that, I don't want to get too legal here, that breach of that act is contractual damages. That is what put the person back in the place they would have been had there been no misrepresentation. So there's no automatic right to cancel the deal. It would have to be looked on the facts.
Fabulous. Thank you very much, Ian. So this next question is for you, Mario. And this is one that I imagine comes up quite a bit. I want to buy a used car off of Craigslist. And the questions are, what kind of paperwork do I need? And how do I know that the seller is legit?
And I think I would like to flip these questions around a little bit, because I think it makes a little bit more sense to start by asking yourself, who is selling me this vehicle? So if you're buying a car from Craigslist, one of the things that you are hoping to do is first ensure that it is actually the owner of the car who is selling you the vehicle, and it's not some random party who is either um, selling someone else's car, or it's a stolen car, or something like that. One of the things that you can do fairly quickly to make sure that that's the case is look at whether they have additional posts for other cars. So if they have multiple posts, then that's a warning sign that they are doing something that is against the law in BC, which is selling cars without likely having a license to sell cars. That now, if they're selling multiple cars, you might want to go online and check whether they're actually licensed dealers. You can do that, and I think they will be providing a link here in this presentation. Other things that might strike you as a little bit odd, particularly coming from a online post, and I think this applies overall not only to cars but other types of products or services that are being sold, is if they're offering you the moon for almost no value, right? So if they're offering you a new Tesla or a brand new Tesla for $2,000, that's very unlikely to be true. So those are kind of warning signs that you want to start thinking about. And as I mentioned at the beginning, it's not a bad idea to start taking screenshots or copying text messages that you are receiving from the seller that are making some sort of representation about what the car is. Now, I think something that is potentially, and now we're getting into what paperwork do you need. But one of the things that I think it would be fairly advisable, it would be to get together with the seller so that when you're going and processing the transfer tax form with ICBC, you actually can confirm that the owner, you can compare the name on the owner the registration, the insurance, and that when that's being canceled and it's getting transferred to you, that everything lines up essentially, right? Because that's a good opportunity for you to figure out whether there's some issue with the car. You get a chance to look at the car yourself, you get to meet the individual, and you get to make sure that the process of the car getting registered under your name can go smoothly, and with the person beside you. Because if you do it at separate times, then you might risk the fact that something got wrong and you already paid the person and the person disappears from the face of the earth, and then you cannot find them anymore. So paper wise, you really don't need much other than completing the transfer tax form, and then of course you setting up your own registration and insurance. But other than that, it can be very simple. Now, and again, walking back to some of the, let's think cautiously around what we're doing, is you may want to get in paper what it is that the seller is telling you about the car. So if the seller said this car is fully serviced, make sure you get that in paper. If or in a text message or something that you can actually use later on to prove it. Because if again you just go out and say they said that this was the case, that can be tricky to prove in a particular context where you need evidence about what happened. So that's what I think you would need to do in this context. Yeah.
Fabulous. Thank you so much, Mario. That's really helpful. And I think your point about not handing over your money until you've got some security on knowing that your paperwork is going to clear is probably very wise advice. Ian, this next question is for you, and it follows up on something that I think may a question that came to mind for me, which is this idea of you're registering your vehicle. What if that vehicle has a lien registered against it? How do you find that out? And so this question, I'll read it to you. I thought I had bought the perfect car until it got towed away. Turns out it had a lien on it. What exactly is a lien and what options do I have?
Well, to answer the first part of the question, a lien is what's known as a security interest. So your bank that you've financed the purchase of the car, you grant them a lien on the car that has security interest in the car, and that means the bank has a right to take possession of the car if they don't get paid. So that's generally in law what a lien is. And in these situations, it's a very complex area of the law of what you can do. You have some rights under the Sale of Goods Act. There's also whether or not you took possession without knowledge of the lien, whether you should be absolved of having to be responsible for the lien. What we say for us in the Sale of Goods Act requires a merchant who is selling a vehicle, in this case, to warrant that they're doing so with no encumbrances on the car, no liens are on the car. So a motor dealer must make sure that when they sell to you, there are no liens on the car, or if there is, that you are made aware of the lien and you agree to take the car with the lien on it. Some people will do that, like they'll take over a lease, in which case there may be a lien on the car. They may decide that they will take on the lease instead of another person. So what options do you have? There's several options you have. One is to demand that the vehicle be returned to you because you, the owner of the car, did not grant the lien on that car to the bank. If that doesn't work, that demand, you can actually then file something in the personal property security registry, which is a demand on the registrar to remove the lien against the car that's registered with them, because you're the owner and you did not grant a security interest. The problem with that is the bank may then apply to the court to confirm the lien, in which case you're now in this court action, which is in the BC Supreme Court, which can be very expensive. If it's a motor dealer and this happens, we have a compensation fund that specifically addresses this particular issue. If you've had the vehicle seized and you're out of money, or you've paid the lien to get the car back, you can apply for compensation to cover that lien. If you file a complaint, we can then also go to that dealer and say, you sold the car with the lien. It's implied that you promised to ensure the lien was cleared upon the sale. You have an obligation to clear that lien, and we can work with the dealer to make sure that happens as well. So there's various options. It can be complicated, and unfortunately, it often gets involved with the BC Supreme Court in this case, which can be very costly. I don't want to get into too much more detail because it gets very legal after that. But I would say you start by demanding that whoever has the lien, the bank or the finance company, release the car to you because you did not grant that company an interest in the car. You're the new owner.
Excellent. And so, Ian, what I'm understanding from you then is if you're buying from a dealer, the dealer has a requirement to disclose any liens that are on the car. In some cases, the purchaser may go ahead knowing that there's a lien. If it's related to a lease, for example, they may assume or take over that lease. And that if you do go through a dealer, there's a fund. There are certain protections that are built in to you.
Yeah.
Okay, so that's one example. And thank you so much for that, Ian. Mario, do you have anything that you would like to add in respect of the liens as it may apply to private sellers, for example?
One of the things I think, and again, important to when you're asking the seller of the car, if there is anything particularly obvious that you should know about the car, so whether there's any defects or whether whether they think a particular repair is in order or something like that, you can ask directly whether they actually have paid out the car in full. That's a way to figure out whether. So for example, I own my I bought my car, but through financing, and I want to go out and resell it right now. Essentially, the bank that financed my car right now would have a lien on my car, exactly as Ian pointed out. So if I sold that car, the lien goes with the car. It's not on me personally. So whoever bought it would have to address that issue. So one of the clearest things is get in writing. There's no liens, and other than what Ian has already kind of prescribed, you can trust in this particular case that's what happens. Now, if you've run into issues, then you can take the same steps that Ian has already outlined to try to start to address this issue.
Excellent.
Paul, if I may just add one thing, sorry to interject. There's one other thing a purchaser, a prospective purchaser may do before buying the car is to get the VIN number from the purchaser or from the seller. And then you can run something called a Carfax report. And when you go to run that report, specifically check off that you want to do a Canada-wide lien search. The liens are registered by provinces. So there could be a lien on the car registered in BC, but the car might be in Alberta. Or let's flip that. If the lien's registered in Alberta, if you do a lien search in BC, there will be no show up of a lien. So that's why it's important to do a Canada-wide lien search. So Carfax will check each of the provinces for a lien. And they'll get most of the liens. Sometimes there's a delay in registering the lien. But this is something you can do before you purchase the car. And quite frankly, if the sellers want to give you the VIN so you can run a Carfax, that's a red flag to avoid that transaction in the first place.
Thank you, Ian. That was I was dying to ask that question. Is there a way of figuring out on your own if there are any liens registered against a vehicle? And so this getting the VIN number, doing the Canada-wide Carfax search, and understanding there may be a delay in terms of what may have been registered, but assuming it hasn't been just recently registered, you should be catching anything that's been registered against the vehicle. And I think a point both of you made is that those registered liens run with the vehicle. They are carried on the vehicle, not the person who is selling that vehicle. So you adopt whatever that lien is as the purchaser. So this is our last prepared question, and then we're going to jump into some live questions. This question is, I bought a used car from a private seller who told me it had a warranty. Now the dealer says it was canceled. Can I go after the seller? And how do I deal with the voided warranty? So Ian, this question is for you. Love to hear your answer here.
Yeah, so if it's a private seller and we've documented or stated, it's a contract, make sure you try and get as much information in the contract as well. If they said it has a warranty, get that in writing if you can. Otherwise, it becomes a he said or she said situation that you have to prove. Generally speaking, yes, you could try and go after the seller. You've got a representation, there's a warranty, so you bought the car under that pretext. What you'll be entitled to will depend on the situation. And the same with dealers. We've had situations where dealers have warranted vehicles and the consumer's gone back with the issue and the dealer said no, and we've enforced their representation to the dealer, to the consumer, that they've warranted the car for a certain period of time and made them honor that warranty. Now, you also talked here about how do I deal with the voided warranty, and I'm assuming that the manufacturer, this is a manufacturer's warranty, and the manufacturer's voided the warranty. This does happen from time to time, and there are various reasons for a manufacturer to do that. For instance, if the car has been modified, like a performance chip has been put into the computer system, manufacturer will usually void the warranty, at least as it relates to the powertrain. Other modifications, like having a pickup truck and you raise it up, 6 inches, that will usually void the suspension warranty. And if it's ever been, a vehicle's been in there for a flood or even in a major accident and substantially repaired, a dealer may void the warranty. So the first thing to do in those situations is talk to the manufacturer and say, you bought this car, I understand there's a manufacturer's warranty on it that you've avoided. I'd like to know the reasons why you've avoided it, and then engage in that conversation of why you think that they should honor the warranty. Again, manufacturers are customer driven. They want to keep customers happy. The word of mouth advertising is important. So that's where you start. After that, an actual manufacturer's warranty is another contract. And so you would actually have to ask the courts for assistance in enforcing your rights in the contract. First to declare you have those rights and then to enforce those rights.
Super. Thank you so much, Ian. We're going to move now into the live questions. So I'll stop sharing my screen. And while I look at the I have to do that to open my Q&A. We're going to turn to a question that came in through our through the Q&A in our website, which is this: how much information are you required to give someone before you test drive the vehicle? I had a dealer ask me for a copy of my driver's license. And Ian, would you please answer this question for us?
Yeah, actually, several years ago, the Privacy Commissioner weighed in on this and provided direction to the industry on this. The Privacy Commissioner of BC said that the dealer's entitled to know the name, address of the person, that there's a valid driver's license, so the driver's license number, the issue date, and the expiry date. That way, the dealer can know that the person is legally allowed to drive, there's insurance coverage, and if there's ever any damage or any violation tickets that sort of pop up a few years later, or not a few years later, a few months later, that the dealer can then go and address that with the person who test drove the vehicle. Beyond that, the commissioner said you don't need to know the other stuff that's on the driver's license, weight, height, sex, all that type of stuff is not necessary for test drive purposes. And that you should be, the dealer should be destroying that information once it's no longer necessary for the dealer to keep that information. And what is a reasonable business period of time? Like I said, a couple of months is probably sufficient to address those issues about damage and violation tickets. The letter from the commissioner to, in this case, the New Car Dealers Association BC is on the commission's website.
Fabulous. Thank you so much, Ian. And we'll be provided a link to that as well in the with the recording of the webinar. Here's a question that has come in from one of our audience members today. If a private seller writes that the vehicle is being sold as is, does that protect the seller from having the purchaser come back with any problems at all? And Mario, would you feel comfortable answering this question?
Yes. So again, one of the things that it's important is because the law implies legal warranties into the agreement. It's going to be very dependent on how there has to be an express language. So it has to be very clearly stated that no warranties are going to apply. I don't think just saying your agreement, this car is as is, you're just taking it as is going to satisfy that requirement. So the seller really has to go out and say, I'm not giving it, like I'm taking away this legal warranty that you have, and you have no right to come out and enforce it afterwards. So when someone's telling you that, that is potentially a very big red flag for you to go ahead and purchase a car, because essentially what they're saying is you have no basis to complain about what I'm selling you right now. So you have to be very clear on what the language in the contract is saying, to make sure on one side, if you're the seller, to take away that right that is imposed by law, and on the other side as a purchaser, to make sure that you're accepting the risk of buying a car in those circumstances. So I would pay very close attention to the language in the agreement, and I don't want to characterize it as lazy drafting and just saying as is. But it creates issues down the road, because there could be expectations from both sides when in as if it tends to be used as take it as is. But it could create issues. So the clearer the agreement is, respecting what is being given and what is taken away, the clearer both parties can be on what the exchange actually meant. So.
Thank you, Mario. I really appreciate how you looked at it from both the seller's perspective and from the purchaser's perspective, in terms of narrowing down what that means, that as is itself isn't all that specific. So if you're a seller and what you're really trying to do is step out of any type of implied legal warranty, that you need to be expressly clear about that. And if you're the seller, or sorry, the purchaser, you really want to know, I mean, as you pointed out, this may be a red flag that what you're about to, the vehicle you're about to purchase has some major issues, and maybe you're okay with that, but to get very granular about what it is that you're about to step into. Thank you. This next question is about liens again. Is there a possibility of an unregistered lien affecting the sale? And is it registered after purchase? Ian, may I ask you about that one?
Yeah, there are a few liens that don't necessarily get registered right away, but they all can be registered. Um, the one thing I can think of is a mechanic's lien. So you've repaired the car, and the mechanic has an automatic right to security interest in the car when they've put labor and parts to it. You can register those liens, but they don't necessarily have to be registered right away. So that can be one. Another one is a warehouse lien. So if you've had your car in storage somewhere, the person who owns that storage facility has a right to lien to your car for the payment of the fees for storage. Again, that doesn't necessarily have to be registered. In those cases, you would simply say to a court or whatever, I was unaware of the lien, I took the car without knowledge of the lien, I gave fair value for the car, and I should be able to take the car without the lien, and the lien should stay with the person who owned the car, and the courts usually will agree to that, usually.
Fabulous. Thank you so much, Ian. Ian or Mario, if either of you has an answer, how certain can I be that ICBC clearance on the vehicle after a dealer rebuild is reliable? Would you be able to answer that question?
Yes, I can. And first of all, ICBC doesn't issue the clearance. The Ministry of Transportation Commercial Vehicle Safety Enforcement Branch has a program for the rebuilding of vehicles. A rebuilt vehicle, a salvaged vehicle that's purchased and rebuilt, has to pass both a structural integrity assessment as well as a mechanical inspection assessment by a designated inspection facility. And it's designated by the Ministry of Transportation. Up till about 7 or 8 years ago, I would agree that the process was a bit lax with oversight. Since then, we've seen the process to become more stringent. For instance, pictures of before and after repairs have to be provided to the Ministry of Transportation and so forth. And we've seen a decrease in these types of issues with cars. One of our major cases was a dealer here rebuilt a vehicle to substandard standards and sold it, and the person went out to Ontario and the car was taken off the road. So we dealt with that, and that's one of the cases where we said the dealer had to pay for the entire car to be taken back, and we actually removed the dealer from the industry because of what they'd done was very deceitful. That was when those process for overseeing those repairs was a bit more on the lax side. In my seeing in the last few years, it seems to have come down a bit. It's not to say that it can't happen. I'm not going to guarantee every car passes, but the standards for assessing and overseeing that rebuild process have been increased in the last, I'd say, 5 to 7 years.
Fabulous. Thank you so much, Ian. And thank you, Mario. We're nearing the end of our time. And so we're going to say goodbye. So thank you, everybody, for joining us. And before we do that, Mario, do you have anything that you'd like to say before we conclude today's webinar?
I certainly appreciate the opportunity to join here today. It's always a pleasure working with the People's Law School, and I encourage the work that you are doing, and I hope the information that we've provided today has been helpful for those listening.
Thank you so much, Mario. I know it has been, and likewise, we really appreciate all the contributions that you make to our programming and to the resources that we have on our website. So thank you very much. And how about you, Ian? Any parting words for our guests today?
Well, I want to thank you again for the opportunity, and I really appreciated the questions that came out of the chat sessions. They were great questions, and certainly stimulated my brain on that last one.
Well, thank you so much, Ian. I'm delighted that you had an answer. I was looking at it thinking, this is a really interesting question, and I'm delighted that you were able to answer, and for all of the contributions that you've made. We thank you as well. So thank you so much for joining us.